Mary Fitzpatrick, please.
Gurmagad Kirlock, and thanks, Minister, for coming back in second time today. So we appreciate your time. We also appreciate all of the efforts that you and the Department have put into trying to tackle the crisis that is affecting far too many people who are renting their homes today, not just in Dublin, but in Ireland. We all know that rents have become unaffordable. I guess it's for that reason that this government, this new government, has legislated no less than 5 times since coming into office to actually try and tackle the rental unaffordability crisis that is affecting far too many working people and far too many of our citizens. And it is really a corrosive effect on our society, housing poverty. It deprives people of their opportunity to go to school, to go to work, to get on with their lives. So this is a really important piece of legislation, and myself and the Fianna Fáil group obviously will be supporting it. And I really would urge the opposition to act responsibly when it comes to this legislation, to this debate this evening. And I know we are set to adjourn at 10 o'clock, but we're also scheduled to deal with it later in the week again. This is a really important piece of legislation for people who are renting today, for people who are dependent on the rental market. And it is reckless and really irresponsible to talk about introducing things that are not legally possible and that will only make a bad situation worse for renters. Senator Cummins talked about the rent freeze that was attempted in Berlin. That really did have a disruptive effect. Not only did it reduce the amount of rental property that was available very significantly, it compounded the situation for people who were renting by leaving them in limbo with 2 types of contracts, where there was shadow contracts, shadow leases, where there was an overhanging burden on renters of a debt that they didn't know when would be demanded, when would be collected. It didn't apply to properties that were built after 2014, and there was a whole raft of other exemptions. But ultimately, it was found to be illegal. And I've heard, not you, Senator Warfield, but I've heard the spokesperson for your party deny on the national radios that he ever called for a rent freeze, and then in the same breath actually not only demand a rent freeze, but demand a reduction on existing rents. If he wants to, and if Sinn Féin wants to communalise all of the private property in this country, I think they need to come clean and say that. They need to tell the public what they're actually proposing, but most importantly, they need to tell the renters of Ireland what they're proposing. And they need to accept that this legislation will put on our statute books caps on rent. They will provide renters with certainty in terms of the duration of their tenancies. It will give them extra protections. But this isn't the only action that this government is taking. In Housing for All and in all of the initiatives that have been taken, 20 billion euros of capital, Sinn Féin called for us to increase the capital spending, we're increasing it. For decades it's been spoken about affordable cost rental. We're delivering affordable cost rental despite the objections from opposition, despite the legal challenges. Even last night, 850 homes, public homes on public land in this city, where you talk about the unaffordability of housing, you voted against it and you continue to oppose. So not for us. We can spend all tonight and we can spend later this week debating it. But be honest with the people outside this House who do desperately need a solution to the rental crisis that they're trapped in. And support this legislation. Support it to give certainty, to give them tenancies of indefinite duration and to put caps on the rent. Because the reality of it is that it is going to take time to build the 300,000 new homes. It is going to take time to build the affordable cost rental. But they will be built and they will be delivered despite your opposition. So I'd ask you to be constructive in the debate for tonight and the rest of the week. Gurmagad.
Senator Fitzpatrick, Senator, our Minister at this juncture. There will be other opportunities. Minister, please.
Thank you very much, Cathaoirleach. I wish to flag at the outset that the Government will be making a consequential technical amendment at report stage to Section 3 of the Principal Act. I cannot unfortunately accept Amendment 1, which proposes that the setting of a rent under tenancy of a dwelling may not occur in the period of 3 years from the commencement of Section 3 of the Residential Tenancies Amendment Act 2021. Besides the difficulties with a blanket ban on rent increases, which I will address presently, the amendment, as drafted, would have significant unintended consequences. As provided for in this amendment, the setting of a rent under the tenancy of a dwelling in a rent pressure zone at any time after the commencement of Section 3 of this bill may not occur in the period of 3 years from the commencement of that section. On the face of it, this means that rent settings cannot legally take place for 3 years, even where a new tenancy commences in respect of a rental property. Whilst freezing rents for existing tenancies, this amendment would also stop new tenancies being agreed for existing rental properties. Now more than ever, we need investment in the sector, and people need to be free to move within the rental sector as their needs change over time. The proposed imposition of a 3-year rent freeze has been debated numerous times in both houses of the Oireachtas. As has been said before, a blanket ban on rent increases in all likelihood would face significant legal challenge. It would also severely impact the investment in the supply of rental accommodation in the medium to longer term, and I am sure that senators would agree that this would be a very unwelcome and unintended consequence of this measure. While affordability remains an issue, the introduction of rent pressure zones in 2016 and their subsequent enhancement in 2019, in July of this year and proposed here in this bill, have played and will play a key part in moderating rent increases. Rent pressure zones were considered a measure that was balanced the needs of tenants with the legal rights of landlords and the imperative to ensure that rental housing supply was not adversely affected. The current rent pressure zone arrangements, under which annual rent increases are prohibited from exceeding general inflation, are recorded by the Harmonised Index of Consumer Prices, were introduced as a balanced set of arrangements which recognise the need to incentivise in situations of high and significant increase in rents, while at the same time taking account of constitutional property rights and the need to avoid disincentivising the provision of rental properties. While introducing these measures, the Minister was very clear on the need to carefully monitor inflation. At the time, the Harmonisation Index of Consumer Prices inflation averaged at 0.73% per annum over the previous 3 years, but had risen to 1.6% per annum in the year ending June 2021. The Minister needed to revise the rent pressure zone rent control relatively quickly in July, on the basis that it could be independently verified. Given the continuing rise in the Harmonisation Index of Consumer Prices, inflation up to 5.1% per annum in October, this bill proposes to introduce a cap of 2% per annum pro rata to any rent inflation in the rent pressure zone to ensure that effective rent controls are legally in force when the general inflation rate is too high and over 2% per annum. I cannot unfortunately accept Amendment 2, which proposes to remove a reference to, quote, relevant percentage, unquote, as defined in Section 3 of the bill and replace it with a flat 2%. This would, in effect, cap any rent increase at 2% regardless of the time elapsed since the previous rent setting under the tenancy. The definition of relevant percentage in the bill permits a 2% per annum rent increase since the previous rent setting, whether the setting occurred under the current tenancy or under the previous tenancy. The aim of the definition is to avoid incentivising a landlord routinely increase in a rent pressure zone on an annual basis. The Residential Tenancies Acts generally provide that a rent review in an RPZ cannot occur any more frequently than once per year. The definition would allow for existing tenants to enjoy occupation of their home under tenancy without annual rent increases, should the landlord so wish. The landlord could forego annual rent increases for the existing tenants in the knowledge that he or she could legally increase a rent by 2% per annum pro rata when any replacement tenancy is agreed. For example, if a landlord had set the rent at €1,000 for the existing tenant and did not review the rent during a 3-year tenancy, he or she could legally set a new rent of €1,060 if lower than the Harmonisation Index of Consumer Prices inflation for the subsequent tenant. We do not want to incentivise annual rent reviews in rent pressure zones for existing tenants. We do not want to impede a landlord from charging a reasonable rent for the dwelling based on the time elapsed since the previous rent setting and taking into account the time value of money and costs in maintaining and providing rental accommodation. 86% of landlords own 1 or 2 properties. We need to encourage landlords to provide much needed accommodation in the private rented sector. This measure would unfairly penalise good landlords and drive away investment from the sector. I cannot accept opposition amendments 3 and number 4. I appreciate that they propose in effect to reduce the quantum of any rent increases that may lawfully be imposed in a rent pressure zone. However, as with Amendment 1, the proposed amendments in effect would freeze rents at their current levels. As you know, any proposed measure that impacts on the private property rights requires detailed consideration and scrutiny, having regard to the provisions of Article 43 of the Constitution and the associated legal complexities. At second stage, the Minister explained that this bill will cap any rent increase in a rent pressure zone at 2% per annum pro rata. This measure has the approval of the Attorney-General, and the Government is confident that it is fair to both tenants and landlords and that it will have a desired impact in the rental sector. The Planning and Development, Housing and Residential Tenancies Act 2016 introduced the rent predictability measure to moderate rent increases in those parts of the country where rents are highest and rising fast. The proposed rent increases cap of 2% per annum pro-rated in rent pressure zones, if lower than the harmonisation index of consumer prices inflation, in the bill has regard to the constitutionally protected property rights of landlords and takes account of local rental market factors, providing certainty to tenants and landlords with regard to medium-term rent levels. Throughout this pandemic, we have asked landlords to show forbearance towards their tenants where they may be struggling financially, with some requiring state support. In order to better enforce rent pressure zone legislation, the Residential Tenancies Amendment Act 2019 provided the Residential Tenancies Board with enhanced powers and resources to carry out investigations and to sanction landlords if required for any contravention of rent increase in a restricted rent pressure zone. The maximum sanction is €30,000. Alternatively, a tenant may wish to refer a dispute for resolution to the RTB, and a lawful rent can be enforced and damages of up to €20,000 can be awarded to the tenant. The Department, the Housing Agency and the Residential Tenancies Board keeps the operation of the rental market under constant review. It is important to have transparency in the system with fair rent and certainty for tenants and landlords alike. Thank you, Caroline.